So, most of you know who I am, but I would still like to introduce myself. I am Pooja Bhatia. I have now created a company called as Innoberry LLC, which helps in not just uh, protecting IP, but also effectively commercializing it. In addition, I am helping IP professionals in deciding whether they would get into licensing or not. So that is whether they would like to expand their existing skills, whether they would like to get into the field of licensing, making those decisions, helping them with the coaching part, simplifying their path from my experience to tell what more they could do to get into this field. Since you all have joined me today, I am giving two takeaways for you. Besides the interaction and lot of information, one is a 30-minute free coaching session, which you can attend with me, where I would be helping you in understanding the next phase of your career and how you could reach there. What are the skills that you need to add on? There's another surprise takeaway, but you'll have to stay till the end to know what that exactly is. In this session, we are going to talk about what patent licensing is in very brief, who the applicants are, how they influence the entire process, what kind of complications come in when we have too many applicants on a particular patent application or a granted patent, and what is the solution you could work out to ensure, if you are looking at it for licensing, how it goes smooth. The objective of doing this session is basically to ensure that, as a patent professional, we are always trying to help in getting a better protection for an invention. But there are some other factors that we also need to consider. For example, licensing. If a patent application is not drafted properly, or not protecting the invention adequately, or there are other applicant and inventor issues, or there are too many of histories related to the application, then it leads to complications. I would be talking about the complications in other slides also, but we need to spread the awareness among the patent professionals also, that if you want to make a IP licensable too, you just don't want to help your inventors, your clients, to just file them, but you also want your clients to make something which is transferable or licensable to some other party. If they're not using it, if it's just lying on their shelf, definitely they would like to, remove it and make space for other products. The other thing is that when you know this point of view, you can argue well with the inventors and the applicants to ensure that, the right people are named as applicants. Why this session came to my mind is that, I have seen a couple of posts on LinkedIn where many of my friends have posted a grant of patents which have multiple applicants on it, including individuals. And when I, as a tech transfer professional, see that, it pains me, because I know it's going to be a hell of tough time for me to license that out. And I don't know if that's the end goal or not. But if that is the end goal for you, to help your client not just protect, but also commercialize it, then you have to keep in mind few points, which will help you in, increasing the chance of commercializing that particular patent, and also making your life a bit easy. So now, what is the process of patent licensing? Presume you are an inventor, you have created something, you have put in money to develop it. Now, you are looking for partners to license it out. Partners could be other companies, it could be your own startup, so it could be licensed to self or to third party. You could either give out the rights for money right at the beginning, or once you give out the rights to the other party, then you could generate revenue. Now, patent licensing differs from the complete buy-off. Patent licensing is when you are only giving the other party the right, maybe a limited right, to use their patent for selling the product based on that patent. Your patent could be a product or a process patent. So the licensing would depend upon what type of patent you have, or do you have a portfolio of patents which you are licensing. But whatever you have, a single or a double or many patents that you are wishing to license, you would need to look for partners who could take it ahead, partners who have the capability, who have the technical expertise to take it forward. And they also have moolah, they have money to invest, because without the investment, you can't move the product from the bench to the market. Now, in the entire licensing process, there are many stakeholders who are involved. The inventors or the innovators who actually think of an idea, think of a solution to a particular problem, and develop it. Along the way, they need investments, which comes from different funding agencies. They could be government, non-government corporates who are helping you in solving a particular problem. Now you have developed the technologies, then come into the picture patent professionals. Besides the patent professionals, you need professionals who would help you in many other aspects. For example, contract research. You don't have the resources at your end to completely develop the product, or even maybe test it out at a POC, which is proof of concept level. Then you need help from external parties. So these are two other stakeholders in the entire process. Then you are looking to give it out to other companies who would actually take it forward. So now, right from the ideation to its protection to its commercialization, there are so many parties that are involved. When there are too many parties involved, there are, obviously there would be complications which arises, but for today, we will just be focusing on the applicants who apply for the patent application. And when you have two or more applicants on a patent application, then what kind of complications arise? Now, who could be, there could be different types of applicants, right? Who could be the probable applicant? It could be either individuals, it could be organization. Now, organization can be an institute, or it could be companies. It could even be a startup. You could have a mix of institutes and institutes. You could have a mix of institutes plus companies. You could have a mix of institutes, companies, and individuals, or just individuals per se. So if you look at it, there are so many combinations and permutations which are possible. You could have an national institute, you could have an international institute who is collaborating for a particular invention. You could also have a startup who has come out, who has a bright idea, but they don't have the resource. They reach out to an institute to collaborate with them. And now they have a patent application that has been filed in both their names. You could also have inventors, as I have seen in most of the applications and the posts that are being done, that there's a combination of institutions, companies, and as well as individual innovators. So there's a 3-level and 3 different categories of applicant on one particular application or a granted patent. So now what are the complications that arise in such situations? If you are a tech transfer professional like me, trying to transfer it, there are too many people to coordinate with, right? You will have to coordinate with each one of them to arrive at a particular decision. The decision making is not going to be easy for you because there are so many layers. One would agree to one aspect, the other would agree to other aspect. So you have to deal with all of them. All of them have different perspectives. They have a different thought process. So it's going to be difficult to reduce the time involved when you have too many people to coordinate with. I'll give you an example of a case that I had handled where it was a startup. They had filed an application and there were 8 individual innovators, founders who had named themselves on the application. They didn't wanted to file the application in the name of the startup. They wanted to later on license it to it. And all 8 of them were going in different tangents. They were not even sure what they want to do. And in such a situation, it was elongating the time, which was such a simple case to license it out. It took such a long time. I took an year to finalize the agreement with them and get it finally licensed. And after that, it added value to their startup and they could start raising funds and apply for grants. So to cut down the time, ensure when you have too many people with different perspective, it will definitely increase your time. So we need to ensure that the time gets reduced, our deal gets quickly done. Now, with most of the institutions and organizations, be it any company or a larger corporate or an MSME, they would have their own policies and ways of doing things. They would not necessarily do the things as you are doing. So you have to comply with their policies. You need to know what their policies say in order to you know uh, work with them. How do they work? Their way of working would also differ. There would be different tiers of approval level that is required. It's easier in individual, but when you're talking about a company, and let me add on more complication, it's a government company, so you'll have different level of approvals that need to be taken in. So your more and more time gets into all this thing rather than focusing on the deal itself. Then there's another thing called as rights. What rights do the applicants have? In India, we know that the applicants have the right to uh, have the right to not grant a license to another company or a third party if you do not have the consent from the co-owner. But in other countries, for instance, in US, you can license it out without the permission. So when you are dealing with another, with an institution or from any other company from any other jurisdiction, as a patent professional, you need to check back the patent law to see, are there any specific rules, are there any specific case laws which are going to hinder you, right? Now, consider an example where you have filed an application for one of your clients who is based in India and their counterpart is in US. Now, the Indian applicant cannot license the Indian application unless and until they have the approval from the US counterpart. But it's not same for the US one. The US co-owner can easily give out the license without taking your permission and would not even share the revenue with you. So this is another complication that you need to be aware of when you are licensing a technology, or when you are working with any client for protecting of their patent. This is another useful input you could give to them when you know they are collaborating, just to ensure you are advising them right. But the aim is not to get worried by these complications. Keep moving and you will find the solutions. What are the probable solutions? There are 4 that I could give you. One is stay updated, stay abreast of what are the patent case laws that are going in different jurisdictions. If it's not, obviously it's not possible to continuously read, but before you are working with any of the clients, try to screen through what are the useful case laws, what impact they may have for such a patent. Right now, as patent professional, yes, our focus is on protecting the invention. But over the period of time, with the shift in the perspective of the clients, also the push through the government, there will be a push for more and more patents getting commercialized. In any case, we need to also submit the working statement for the Indian patents. So there again, we need to show that the patent is either working or has been licensed out. So for such scenarios, excuse me, for such scenarios, you need to, ensure that you have strategies, which is ensuring that you have a patent that could be easily licensed out, doesn't have too many of complications. So you could keep yourself updated with respect to what is going on in a specific jurisdiction where they are trying to protect an IP or a patent. How is it going to impact the overall process, not just in protecting, but also in commercializing? Then about the policies part, unfortunately, most of the institutions may not have some policies related to IP. Some of them may have, some of them have policies which are not clear. They will not specify things or they are limited in view. So the policies of the institutions or the organization with whom you are dealing, you will have to see if they have that policy, you could recommend to them, if they don't have a policy, to create one to smoothen out the process, because when they are negotiating with another party, they can always show that policy that we have this set process and this is what we are going to implement. When you don't have a policy, it becomes challenging. You don't have anything to prove that, this is the way you are going to work out. While I was working with one of the cases, they were trying to implement their policy, but luckily the institute that I was representing, they had their own policy. So we could counter argue that, the policy has these factors in, these clauses there, and we need to respect the policy which is already there. And then the other party was willing to collaborate on a better terms because we already had a policy in place which was useful. The most important thing in the entire solution is to ensure that when you have multiple applicants, there is an agreement between the applicants. What would the agreement specify? It would depend upon between whom it is, but in general, it should specify who's responsible for the patent filing, who's responsible for the tech transfer, if it happens. Are they all going to decide for each jurisdiction, or is it, you have divided the jurisdictions? For how long are they going to be the deciding partner? Excuse me. If they would be willing to assign it back to you. For companies, that is very crucial because then you are a single owner. But yes, it brings in liabilities because you will have to shell out the entire money for protecting and maintaining the IP. But then it also makes life simpler. In the agreement, you could also ensure that there is, when you are dealing with your clients, have a separate agreement with them, telling them to specify who is the point of contact, be it for patent filing or for the licensing part. There should be one point of contact, and getting information from all rest of the point of contact is his headache, not yours. So that way, you are reducing your involvement in the entire process of interacting with multiple people. You have one point whom you can trouble with, and you are getting all information through them. Even though it would still take time, even if you have a single point of contact, because the single point of contact is going to take time to interact with many other people. But then you are going to be saved from a lot of heartache. When we are dealing with different people, sometimes situations happen where they would be, fighting amongst themselves. So then you don't have to deal with all of that when you tell them to specify one point of contact. We were filing a patent application at IIT Delhi, and there was an application where the students kept on coming to me and telling me that, they want this particular thing to be added while their professor is not agreeing. Luckily, at IIT Delhi, we had this procedure that they had to specify the point of contact. So I told them, I'm not going to listen to you. You have already signed an agreement saying that, the professor is the point of contact. So now you can't go back, and I'm not going to deal with you. And whatever fights they had with their faculty, they had to deal with it. So that really saved me from getting involved in that unnecessary thing, which was going to take away my time and not let me focus on my work. And secondly, it wasn't part of the policy to get involved. Now, let's come back to the agreements part. There were a few questions when few of you had registered. So with respect to that, when two institutes, say from India and from some other country, are collaborating, what are the specific things that you need to look into? One is the agreement should be there, a collaboration agreement, which has different segments. One will be totally about how they're collaborating, how the funds comes, etc., etc. The other thing is they look at the role and responsibility for the IP part, the IP ownership. How much are they both going to own? Is it 50-50? Is it 20-80 ratio? whatever ratio is the ownership, they could also divide the revenue and the investment that goes into the protection of the patent. Now, where all to file the patent for the Indian institutions, if they are funded by some of the funding agencies like DBT, DST, then it becomes Department of Biotechnology and Department of Science and Technology. Then it becomes essential for them to file an Indian application. In any case, you may not like to reach out to other jurisdictions, but limit it to India. So in that case, the Indian institution has an key interest in the Indian market. So it is very essential to have an Indian application, but the counterpart may not be interested in the Indian market because they may not have the reach, they may not have connects, so they are not interested in an Indian market, but you are. So that is something that needs to be decided between both the parties, that what are the jurisdiction in which you want to protect. You could have a way where you, when I say you mean that the Indian institution is trying to just protect the Indian application. They pay for all the expenses for the Indian application, and whatever revenue comes from the licensing of the Indian application, they are responsible for it. Now, make the other institution responsible for the other part. Most of the institutions would agree because they want the complete control over the application that they are taking care in that particular jurisdiction. You could have a way where, both the parties are splitting the expenses in 50-50. They have 50-50 rights to decide and take the licensing ahead. But then it is very useful for the institutions to consider how or what are their resources in any particular country. I will share a case where it was funded by one of the funding agencies under a joint project. So there was a university from India and there was a university from Norway. Now, the Indian university wasn't interested in the European market. They were more keen, the inventors were keen to start a startup of their own based on the IP that they were filing. And the university was also in agreement that they want the inventors to start the startup and they will be supporting them. So now their interest was limited to the Indian side. So the negotiation, while it was going on for the agreement, it went like that the Indian university would be taking care of the Indian patent application right from the scratch, filing it at everything. For the drafting part, the Norwegian counterparts would also be involved because this would be a priority application. Based on this, the Norwegian application would be filed. And for the Norwegian application, they would be responsible for the entire expenses because in local currency, it wasn't much for them. So, and then each party were responsible for the licensing of their application respectively. Any decision making was mutual. They had to jointly take the decision, but no consent would be withheld unreasonably was something that was added to the agreement. The points of contact for each university was also determined while negotiating the agreement itself. There was one from the tech transfer office from each universities along with the inventors. So there were two people responsible from each side for their respective jurisdictions. And whatever revenue that comes in was again split in 50-50 because the efforts were jointly put in. Despite the expenses, the way they were covered, it was based on the efforts that went in. And finally, the application was filed. It was filed in 45 days, a complete patent application. And then the inventors, as they had promised, they created their startup and it was licensed out. So now both the universities, it was a win-win for them because they could say that the IP that they had created was actually licensed out to a startup. So there was some impact that they had created, and the agency was also happy who had funded the joint project that there was some impact that was created. So this is one solution to an inter-institutional collaboration. There could be many others, like you could agree to waive off your right if the invention is not applicable in the Indian market. Now, there would be some inventions that would find a market in the Indian jurisdiction, some which would not find. So in that scenario, it doesn't make sense getting rights to an invention which doesn't even find any application in India. So for that, you will need to do a potential market assessment to see how does it fit into the picture. Now, in case of agreements, there's one point that I would like to highlight. Then when you are negotiating an agreement, ensure that its validity is for a larger time, not just 1 year, at least for 5 to 6 years. The second is that you have a neutral jurisdiction, because they may not agree to file a case in India, nor you would be willing to sue them in Norway. So find a neutral place like Singapore. If they agree to India, nothing like that. But if they are not agreeing to India and you are not agreeing to Norway, then you have a solution, or to whichever country they are based in, you have a solution. You could find a neutral country as the country for which the laws would be applicable. Now here, let's consider a situation where you have inventors also on the application. You have the university, you have the inventors. Now, ideally, the inventors should assign their rights to the applicant, and their names should only be in the inventors list, not in the applicant. If they are insisting, the question you should ask them is, what are they going to gain by having their name as applicant? If they already have an agreement with the institute which says that they are assigning the rights to them, and when the technology or the IP gets licensed to another third party, in that case, they would be getting back some revenue. Or if the institution already has a policy which indicates revenue sharing with the inventors, then the inventors don't need to be named in the applicants. So as patent professional, we need to understand what are their concerns. Why the inventors want to be named as applicants? Are they sponsoring the application? In some of the institutions I have seen where they insist that the inventors should pay for the patent filing, and the names of the university should also be a part of it. Now, so you will have to understand what is the main reason and then accordingly advise them. Another thing could be getting an NOC from the institution they are working, so that the institution could waive off their right and give the entire rights to the inventors. So in that case, the patent application only has the inventor or individual category as applicant, and it becomes easy to deal with it. You could tell them to have one point of contact who would be interacting with you, and the rest they could take care of. But then again, all the inventors have to be on the same page. If any one of them don't agree to licensing it out, then it becomes an issue. Like I gave you the example where there were two inventors. One of them wanted to create a startup, the other didn't want to, nor he wanted the first person to create a startup, nor he was letting him. So this was the tactic that he used. Main consent hi nahi dunga. I will not consent to it. So it was a dirty game that he played. But unfortunately, because of the Indian Patent Act, this is something that he could use. But fortunately, the first one went up to the controller and told him that, this is the issue I'm facing, and the controller then got both the parties talking and resolved the issue. So when you have multiple individual innovators, you would still have complications. If you have different categories of applicants, like institutions, companies, and individuals, then again there would be complications. Now, when we have a joint project between an institution and a company, in that case, the agreements would depend upon a lot of other factors. Is the company Indian? Is it an international company? Do they have a policy? Who is going to be named as the applicant? The Indian company or their parent company which is in another country. So there will be different complications that come into the picture. Now, most of the companies who have funded a particular project would not like to give away the patent rights to an institution. They would rather like to take away everything. But in cases where they have agreed to joint application, there should be a clause which says that the institution and the company or both the parties agree to negotiate for a separate license agreement once the application is filed, so that there is a door open and it makes it clear to them that they still have to license it out. It isn't that they are automatically getting it. And there is no automatic assignment, right? You still need to file an assignment with the patent office to show there's a change of ownership. So again, with the company, we have to be, when two different organizations are collaborating, institute and a company, they have to define the ownership depending upon what role they have played in the development of the invention, not just by funding. Funding, yes, is crucial for the development, but did they help in the conceptualization? Did they help in reducing it to the practice? Now, let's think about another complication which arises when you have a contract research organization who has done a certain portion of it, and you also want them to be included on the patent application. First, in some cases, if you have a vendor agreement where you are paying them to do a particular job, like creating a prototype, they have not given you any scientific or technical inputs. They have just created something as per your instructions or by your specifications. So they are not contributing. Secondly, you are paying them to do that particular work. So that becomes a case of work for hire. Again, they would not be named as an applicant. So you need to have separate, the innovators, I would say, or your client would need to have separate agreements with different parties to ensure the ownership lies with them. They don't have multiple owners on that particular application, because not only in licensing, but when you're trying to raise funds and going in for grants, then it will become an issue when the ownership is divided. So now these are the four main solutions to the problem. You need to have one single point of contact. You need to have agreements in place. You need to know the policies. If the organization or the client that you're representing doesn't have a policy, then it would be advisable to suggest to them that, they need to have at least a standard operating procedure on how they're going to take ahead the entire collaboration and licensing and the IP protection part. And for us as professionals, we need to be updated on the case laws that are going on, which may have an direct or indirect impact both on the protection and commercialization. Now, this is the last takeaway that I have for you. For all the participants who are there in today's session, they are going to get 20% off on bundle of all the 3 new courses that are coming up. I would be sending out a link to all of you if you are interested. There are different time slots which are available. So to fix the time slots, I'll be sending you those links, and you could pre-register your interest if you have. The 3 courses are related to the patent licensing. The first one is on marketing of innovations. It will cover 3 aspects: the technology transfer strategy, the technology assessment, assessing whether your invention has a commercial potential or not, and then how to create the marketing content. The second one, which is the 101 of patent licensing, would walk you through what patent licensing is, types, how does it help to patent license, and what are the factors that are going to influence this. In the third one, it is related to drafting of the patent license agreements. One would be a theoretical thing, then we have a practical where you would work with me on drafting the agreement, and also how do you take care of complications and compliances. So these are the 3 courses. If you are taking all 3 of these, you would get 20% off. That is a giveaway from my side for today's session for all the participants. And if you are registering just for 2, then 15%. And now I would be happy to take any of your questions. Thank you so much for your patience and listening to this session. Um, the floor is open for the questions.